So you did say on this program not that long ago, now we'll get to Trump, and I played you and Kurtz.
Yeah.
You said in your 60 years of practicing law, you never saw a weaker indictment than the one here in New York with Alvin Bragg. But then I just heard you with Kurtz, and even though we both admit that this indictment really isn't weak, it's a federal indictment. They seem to get him on obstruction, maybe not, we'll see, but certainly juicier than the first one. You did say, folks, this is not espionage, and really, they shouldn't have done this. You still feel that way?
I do. I have an op-ed in today's New York Post with Andy Stein about how the words espionage should never be used in this case. He didn't hurt the national security. It's a documents case. If he were, running for Congress or something, all right, I can see that. But running for president of the United States against the incumbent who appoints the attorney general, you have to have the strongest case imaginable, like they had against Richard Nixon. And he wasn't even running for office. He was the president. He was being removed. But to indict the man who threatens to unseat your incumbent president, it has to be the strongest case. And I just don't think this case meets the Richard Nixon standard. And does it meet the Hillary Clinton standard, the Joe Biden standard, the Sandy Berger standard, the Pence standard? What should have happened, and I'm very critical that it didn't, they should have appointed a special counsel not to investigate Trump, but to investigate the problem of former government officials taking classified material home with them. Give them a broad mandate. Look at all the people who have had this problem and then make a recommendation. But when you appoint a special counsel, special prosecutor, with somebody targeted, with a target on his back, to a hammer, everything's a nail. And to a special prosecutor, every bit of evidence is directed against the person who you're targeting. That's not the right way to do it.